Mr. O'Neill, good afternoon and welcome. It's not even 6 o'clock in the morning yet, so I apologize.
Would you like me to get you a coffee?
Not yet, but we'll talk in a bit.
All right. Thank you, Madam Chair. My name is Michael O'Neill. I'm the Vice President of Rhode Island Second Amendment Coalition. We're the NRA State Association. I'm going to talk briefly on a few bills, not all the bills. I'd like to talk about 597. This is the stun gun taser bill. This is a really good bill. It gives a victim of domestic violence the choice of using a stun gun instead of a firearm if they're more comfortable at home with that or in the out in public. So I did a lot of research as far as the manufacturing of the tasers, which that portion will shoot out a projectile and it'll stick into the person. So to properly train somebody to even purchase one, you would have to go to a certified trainer and be certified, and then they would allow you to purchase it. Also, what's nice about this, the manufacturers, what they do is if a person uses their taser and they have an assailant that's trying to do harm to them, it'll attach to them, it'll give a 30-second pulse, so that gives the person enough time to run away. And what the manufacturer will do is if you file a police report that you were attacked and you used your taser, they will ship you a new taser free. They run from $300 to $400, which is nice, especially for, someone that, doesn't have a lot of money and you don't want to have to repurchase it. You can just leave it and run, and, that gives you a chance to get away from the situation. As far as the manufacturer's training portion of it, I'm an NRA instructor. I would have to go to their factory, be trained by their people, and then that would allow me to train people in Rhode Island. So it's a good program. The training is really, I saw a few videos on what they use as far as their training aspect, and it's pretty good. It's very informative. It helps the people that purchase the tasers, and so it's very good training. I'd like to move on to the next bill, 595, gun sales transfers monthly to the state police. That's transfers and sales. So that's against the Rhode Island Constitution, also the federal Constitution, because of it makes a registry. And we're not allowed to have a registry in Rhode Island as far as firearms. Who purchased what. So that's against the Constitution. Frank will get into that more. Also, the assault weapons ban, 635, that also runs into the wording in there is registered assault weapon. Again, you can't register assault weapons. The AR-15s, you can't require it. It's against the Constitution in the state of Rhode Island. So right now, Baltimore, Connecticut, Colorado, New York, New Jersey, California, basically all the sheriff's departments in these states have basically said that they will not enforce any type of AR ban. They call it unconstitutional. Kentucky, a few months ago, had a bill in Judiciary. So out of 43 sheriff districts, their head sheriff went down to the Judiciary, 39 of them out of 43, and told the Judiciary in Kentucky that we will not impose any type of assault weapons ban, AR ban, magazine ban. We will not enforce it whatsoever. It's against Second Amendment rights. When you have like Connecticut, and I mentioned New York and New Jersey, they have a registration. Well, in Connecticut alone, they estimated around 250,000 ARs and only 20,000 were registered. So there's a lot of civil disobedience going on across the country when it comes to an AR ban, because the law-abiding citizens are the ones that are paying the price for our mental health issues and our crazy people going in and trying to kill people. So I just wanted to mention that. The 1994 to 2004 ban, the Clinton ban, they did extensive studies, and it didn't bear any fruit as far as making any changes. Crime is at a 40-year drop. It still continues to drop. The only problems that we're really having is like home invasions, as far as they're coming in multiple people at once instead of just one. But also our school problems are mental health and bullying, and that's where our real issue lies. So with, I'd like to go on to the school bill 636.
Go ahead.
So Colonel Manning just answered the question on the 300-foot buffer. My daughters, when they went to elementary school, it was probably 90 feet to the house across the street. Well, now you're going to say that you can't own a firearm in the home because they're within that 300-foot buffer. And then if you're driving down the street and you get pulled over, now you're in trouble again. So it's not really a good piece in that bill. The other, the lady that first testified, she mentioned that there's only 4 states that allow carry-on school grounds, and that is so outdated. Okay, you have Ohio, Missouri, Texas, Georgia, Kentucky, Florida, that have all changed. Texas alone has 162 school districts that have armed teachers, better security, whether it's bulletproof glass or the ballistic film, cameras, metal detectors, armed teachers, if they choose to be armed, they're all well trained. The NRA SHIELD program is specifically for that. They'll go around if you request them to, and they'll go to any state and they'll give their evaluation of the school program that you have. I also sent all of you an email today, and it has all highlighted links on it, and you can click on the link. So anything that I say today is actually in the links. So that'll give you some really good information. So 637, I'm sorry, back to the school bill. I forgot a piece. So as we all live in our homes, if our homes get broken into, we may change the door to a steel door, change the locks, alarm system, camera system, whatever it is that makes our homes feel safer and, you know, protected. Well, since 2013, we've come up here, and we're not doing anything since 2013 to secure our schools. Every time we come up here, it's about the law-abiding citizen not being able to carry on school grounds, and we're not doing any improvements. We're doing nothing for security. Colonel Manning mentioned that he was on the governor's panel, and my colleague on the end read the whole report and basically said that nothing was covered in security. So 9/11, TSA, you know, we have sophisticated equipment, puffers to see if you have explosives on you. You know, it's not cost effective for the state of Rhode Island, but at least we could put more officers in the school. Ballistic film is not expensive. Cameras, 1-point entry. We could do a lot of things that would secure our schools. So to me, that's the real reason why we should be here, is on protecting our children. We're protecting our airports. We protect this building. They made comments that this building is, you know, we can't carry on this building because we're not allowed to, but we also have Capitol Police here. We don't have Capitol Police in the schools. So, you know, that's one thing that really bothers us, that we're, you know, year 7 and we're still not securing our schools.
Mike, can I interrupt?
Yes, sir.
Can I
Senator
interrupt?
Lombardi.
I'm just, for my own edification, what is ballistic film?
Ballistic film, what it does is instead of buying bulletproof glass, ballistic film will go on the back of the glass, and it'll stop a round up to a certain ballistic characteristic. And it works really well. It's inexpensive. So it's really cost effective.
Continue.
I was the only senator with any courage to ask the question because no one really knew a ballistic film.
Okay. All right. Thank you. So the magazine ban, 637. I don't know if you followed in the news, a California judge just basically struck down their magazine ban, calling it unconstitutional. So that's pretty good as far as we're concerned, because if you have multiple times when there's a home invasion, I follow everything that goes in national news, and then I go to the city or town to make sure it's a true event. And you'll find that a home invasion usually is done by 3 or 4 people now, and they all have firearms. So if they have firearms and it's a 12-round mag. You know, you have 4 guys, you got 44 bullets. So you have 10 rounds, because that's all you're allowed to carry, and you get, you know, you pull your firearm, you're trying to protect your family and your home. One assailant you hit, another assailant you hit, you missed the other 2, now you're out, and you're still battling the other 2 with multiple rounds. So all it's doing is restricting us from protecting ourselves because we're on a 10-round magazine ban. So gangbangers, they won't pay attention to that. So that's a real issue. I'm almost
Senator
done.
De La Cruz.
I had a question.
Yes,
Did
ma'am.
you say it was a federal judge that found that
Yes, I believe it was a
unconstitutional?
federal judge, yes.
Okay, thank you.
So you hear a lot from the moms that, you know, we have a real bad firearm issue in Rhode Island, in the United States. So we have 118 million firearm owners. We have 17 million carry concealed permit holders. Now, a lot of states have gone to where it's permitless carry. Oklahoma just did it where 25 and over can carry concealed without a permit. You have Maine. You have New Hampshire just passed last year. You have Vermont, who's never had a permitting system. You have Texas. You can carry concealed without a permit. So all the states are going to permitless carry, and we haven't seen any rise in firearm deaths from CCW holders because we don't break the law. There's more bad shootings from the police officers than there are from law-abiding citizens as far as bad shootings. Now, from the CDC, and again, this is in your email on the link, 2.5 million instances a year where a CCW holder has saved someone's life or his family's life or a police officer's life. There was a shooting in Florida where state police had a guy pulled over. He got out of his car. He rushed the state trooper, and he was pounding on him. The guy pulled over to CCW, drew his firearm, told him to stop, stop. The trooper said, shoot him, he's killing me. The CCW holder shot the assailant, and the police officer was thankful because he thought he was going to die. So this has happened 3 or 4 more times since then. So this is what goes on as far as the CCW holders. We have 30,000 deaths a year. 15,000 are normally suicides. You have 7,800, which are usually gangbangers and criminals. Then you have the rest, which are around another 7,800, which are usually police shootings and otherwise. On the rifle side of it, you have maybe 370 rifle deaths a year. That's not counting just ARs, that's shotguns and hunting rifles and so forth. And I know that we have, again, I've already addressed the school issue. We have mass shootings, and that's a real issue, and that's mental health, that's bullying. That's, in Florida, there was 42 times that the sheriffs were dealing with this kid, and they should have not allowed him to buy a firearm. His mother had passed, so his legal guardian said he bought an AR. He's threatening to kill people online. They did nothing again. The FBI was called twice. They interviewed him twice. They never put him in a mental health institution. They should have grabbed him and not waited 42 times, and now it's too late. Now, Parkland, their evaluation of the whole shooting and stuff like that is a different way than what Rhode Island is. They voted in for securing the schools. They voted in for carry concealed permit holders for teachers to carry, for training, security upgrades, ballistic glass, and whatever. They're full on board with security. So that's what we need. That's the biggest issue. We're here all the time because it's against our Second Amendment rights, and we're not doing improvements on our schools. So 25 years that we've been allowed to carry in school grounds in Rhode Island. We haven't had one incident as far as someone acting out of line or a misfire or whatever. So I just wanted to share that. If you have any questions, I'm glad to answer.
Any questions or comments for Mr. O'Neill? Thank you. Frank, good afternoon and welcome. The button has to be up.
Okay, good afternoon, everyone. Thank you for allowing me to speak. My name is Frank Saccoccio. I am the president of the Rhode Island Second Amendment Coalition. A little background, I am an attorney licensed in Rhode Island, Massachusetts, and all the federal courts. I'm going to go through all the bills one by one. I'm going to try to be as general as possible and hit the points on these because people have told me that I talk too much and I don't know where that comes from. And I hear in the Senate, hopefully I don't break any filibuster rules what I'm doing. I'm going to go over tonight, so.
That's just the floor, but you stop when I tell you to stop. But go ahead for now.
Okay. Okay. So I'd like to begin with Senate Bill 464. It's been labeled as the ghost gun. The problem I initially see with this is the definition of a firearm in there that's listed is very broad. By changing the definition of a firearm, or what was basically before in Rhode Island, which would mirror the federal law, basically the receiver of the firearm. It's a lower portion that holds the trigger assembly. That would be considered to be the firearm. It's usually numbered, has a manufacturing date on, manufacturing information on it, tells the caliber of the firearm. So what happens is when you change that and you change the definition on it, the way you've done it right now makes it incredibly vague. And what happens for some of the attorneys that are on the board, on the panel right here, the problem you have with this is when you make it so vague, people don't know how to comply. When you make it that vague, it may also raise a constitutional challenge to this, because if you have a block of aluminum, a block of steel, and you have the means to manufacture it, somebody may say, according to this, you have a firearm. Even though it's not fully machined, that could fall into the definition of firearm because it is that vague. It's difficult when people are trying to look at this and say, how do I comply with this law? How do I make sure that I'm not running afoul of it? When you make it so vague like that, there's real problems. You need to address that particular one, first of all. There's also no real standards or guidelines with regard to how much manufacturing or how much machining you do onto a block of aluminum, block of brass, or something that could be considered coming close to what now the law defines as a firearm. You also used and changed the terminology in this section and say that any combination of parts, which means now if somebody has a small machine shop or someone has like some tools in their garage, they may be considered to be having a combination of tools and parts that could be considered to be a firearm. Again, we're taking a look at expanding the definition way beyond what federal law already has, and it's going to be difficult people reading this to try to comply with this. So I believe it to be, looking at this to be unconstitutionally vague. There's also on there in this bill, I guess there's some additional language upping the penalties with regard to machine gun provisions. Just a little background on machine guns have been heavily regulated by the federal government since 1986. In Rhode Island, the only people that have machine guns are your police departments. That's it. No one else can own them. It's an NFA item. You can't have them. They're not legal to own. You run against not only Rhode Island law, but under federal law. You're upping a penalty on something that I'd like to hear any one of the police officers come in and say, hey, we had a rash of people we had to prosecute over the last 10 years, maybe 0, that have owned a machine gun in Rhode Island. So you're increasing a penalty on something that's really not a problem. I'd like to move to Senate Bill 597, which is the taser bill. We are in strong support of this bill. The reason being is this finally we can come forward and say there are some real common sense changes to the firearm regulations that we have. This one would be a common sense change that everyone could get behind. If someone chooses not to own a firearm, that's their own business if they want to. But there may be people out there that want to have some form of non-lethal form of protection because they may be able to feel that they would like to have something in the event an attacker comes to them or tries to do any harm to them. This is something that other states, mostly if you look at other states, have already lifted the restriction on. Rhode Island is way beyond the curve, behind the curve on this one. And just so everybody understands, did anybody ever testify to the difference, since you know the difference between a taser and a stun gun? Does anybody have any questions on that? There's differences. A stun gun, you actually have to walk up to somebody and actually touch them with it. It's It's almost like a flashlight. You have to touch them with it, and then that's where the electricity gets transferred and the person becomes incapacitated for a short amount of time. The taser actually shoots out the dots. It goes into the person's body, and that's how the electricity is transferred and incapacitates somebody. The reason why we had two different halves of this bill was because some people may just want for protection to be able to carry something in their pocket, their purse, so if somebody comes up to them, they can touch them and stop the attack. But some people may feel as though they don't want to wait till an attacker is right on top of them. So this form of protection could have a dot that shoots out 6 or 8 feet, and what happens is once it hits that person, they can now drop the taser and then run. The taser manufacturers have it so that it intermittently zaps somebody so that they can remain incapacitated for up to 30 seconds. So that may be something where somebody doesn't want the person right on top of them, but that form of taser would have to have some minimum amount of training in it. We don't want to have people that just buy it and say, okay, I can use it now. That's why we wanted to have the training in there, provision where people have to be licensed to have it because it does shoot out the darts. I thought that would be a really good addition to that so that individuals can have both forms of protection if they really wanted to. Okay. Yeah. Next bill is
Senator Archambault.
Yes.
Frank, I have a question on the taser. Is it a concealed carry or is it an open carry? I'm reading the bill and I'm trying to discern that. I'm not entirely sure.
On the bill, it doesn't have anything that's requiring it to be concealed. So, but if that's an issue, that we can address that. But usually the tasers that they make are kind of small, so they can fit in somebody's pocket or purse. It's like a very small handgun. So there's no real requirement to have it. You probably wouldn't want to carry it openly anyway. Most people have it so they can put it in their pocket or their purse. That's what it's usually designed for.
Okay, thank you.
Usually yellow? Are we talking about the ones that the sheriffs use?
No, those are different. The ones that the sheriffs use are actually designed differently. They actually have a higher voltage. They hit somebody, incapacitate them, but the burst is only for about 8 or 10 seconds or whatever their manufacturer puts on them, just to incapacitate somebody. The ones that they make for people if they want to carry are designed to hit somebody and allow them to get away and run.
Okay.
So there's a lot less a shock on that, and it does it do it intermittently so they can get away. So it's smaller. Also, just want to make sure that everybody is aware of this. Pretty much most of the states, if you do a little research on it, the states that actually did have a prohibition against tasers and stun guns have actually been sued one at a time, and pretty much every one of them's lost. And it has become legal. An absolute ban on them has been deemed to be unconstitutional. Massachusetts just lost that one. I think Rhode Island and maybe one other state and Delaware are the only states left. And we were actually contacted a couple of weeks ago, and they're saying they're looking at Rhode Island and Delaware as the next two. So we should maybe get ahead of the curve so we're not fighting this in court when pretty much every other state has said this non-lethal form of protection should be something that people should be allowed to have. So I think it's an excellent bill. I really think that we should look into it further. So switching gears to Senate Bill 637, which is the magazine limitation on that. Okay. Historically, we had, for 10 years in place, we had the Clinton ban, which limited all sorts of options of firearms. Some of them were banned, and it had a 10-round magazine, pretty much magazine capacity across the board. After 10 years, that bill was allowed, federal bill was allowed to sunset. The reason being is the federal government had 2 independent studies on this, and they've concluded both of the studies, one's like 90-something pages, one's a little over 100 pages. 2 independent studies came back that there was no appreciable reduction in crime because of it. None at all. So we had this magazine limitation ban for more than 10 years, not just in Rhode Island, but all across the United States. It doesn't work. All it does is stop the law-abiding citizens or reduce the law-abiding citizens' ability to protect themselves in the event something happens. We say this over and over and over again when we come up here. Criminals don't care. They got a gun illegally. They don't care what the magazine capacity is. They're going to get whatever they can. So all it does is restrict us. The
Senator Lombardi.
Frank, we received an email or a text of some communication regarding this recent decision in California.
Correct.
Involving this very issue and it being a violation of the Second Amendment rights. How many federal courts have honed in on the issue already? Now, I know that's only a district court opinion, and it's going to, they said most assuredly it's going to go to the Ninth Circuit, I think.
No, I think that is the Ninth Circuit that actually did that.
Why, he's a district court judge. He was a district court judge. And they're saying that it's going to go up on appeal in the Ninth Circuit. But how many other circuits have addressed this issue as it pertains to large capacity feeding devices?
Okay, I don't know the number off the top of my head, but I do know recently New Jersey, which did pass a 10-round magazine limitation, just recently tried to drop it down to 7 because they figured, well, we got it to 10, why don't we drop it down to 7? That was overturned in their Supreme Court with similar language to what this and say, look, you're restricting even the law-abiding citizens from doing this, and it's just an arbitrary number at this point. So even, I know most recently New Jersey was overturned on that. Okay. So what happens is this, and there is the practical application of this is, and Mike did touch upon this before, when somebody is facing attackers, and even if some of the police officers have received training on this, it's usually training where it's not just one attacker, it's multiple attackers coming from different areas. Police train also with different types of threat, low light, different types of light, strobe lights, they chase all different ways. And they train and they have to change magazines quickly because there are multiple attackers. If you're sitting in your house one day, and if this law would pass, I would only be able to carry 10 rounds in the firearm that I carry. All that does is restrict my ability if there are multiple attackers coming at me in my house, okay? So it is a real problem with this. But let me give you another real world application to this. Say this bill were to pass right now. The firearm that I carry all the time, and I carry a 6-hour P228, it's an old military version of a 9mm. It came factory with a 13-round magazine. If this law were to pass, I would not be able to own the 13-round magazine. I drop it down to 10, and all I would do is carry a separate magazine with me. So now, realistically, you passed a bill. I can't carry more than 10 rounds. I'm going to carry 2 magazines. Thank you. Now I'm carrying 20 rounds. Doesn't make anybody safer. I now have to carry a spare magazine just to make sure I feel that I'm protected. If it was such a good bill, why aren't the police voluntarily saying, you know what, we're going to get rid of our magazines and drop them down to 10 rounds, just like the civilians have to do? Not one police officer would say, that makes everybody safer. A police officer's right to defend himself is just as important as my right is to defend myself. If I'm a law-abiding citizen, I should have the exact same right to protect myself as a police officer. If the officers are not turning them in, why should I have to turn them in? It really is a problem with that. I'll switch gears to Senate Bill 502, which is a safe storage bill. We oppose this, again, for a number of different reasons. When I first read the bill, the first thing I think is, this is another further intrusion from the government and the police department into my home. Now, the police department, do they get to come in and check and see if my guns are safely stored and locked away when I'm not using them? What if somebody makes a complaint to the police department? Can they go now get a search warrant to come into my house to double check to make sure I'm in compliance with this law? What about some of the tactical furniture that companies make right now? There are furniture right now that you can make which is safely storage in different parts of the home. Some people like to make sure that there's a firearm if they have a multi-story building on each floor. You're not going to invest in a huge gun safe for everyone, but you'll have tactical furniture. This is safely storing each one of it in each floor. So now, because of this bill, is that considered to be a violation of the law? Am I breaking the law because I'm using tactical furniture instead of a safe? What happens if my home is alarmed and I have 24-hour surveillance and motion sensors? Is that not good enough anymore? Now I have to lock something up like this? This is really going to be a problem where you may have people coming into your house going, I'd like to check and see how your firearms are stored. My home is my castle. I make sure that my firearms are safe. I don't want anybody coming into my house to double check on that. This is too much of an invasion into my liberties on that. Senate Bill 635, which is the assault weapons ban. Again, where to start with this one? Okay, we've had this in place, again, for 10 years with the Clinton ban. Whole classes of firearms were banned, 10-round magazine. Again, no reduction in crime all across the United States. We're doing the same thing over and over again, and it doesn't make anybody safer. It just restricts my ability to be able to protect myself. The other problem is the definition of an assault weapon now is being reduced down to cosmetic features. Now, there are some people I know that are on this committee, and I'm not going to point them out, that they have some knowledge on firearms. And they know the difference between a bolt-action rifle and a .223 and an AR-15 and a .223. Same caliber, no difference in the accuracy, no difference in the range. One may have cosmetic features on it that people go, ooh, big black scary gun. And the other one is a bolt action. People are going to go, okay, you can have that one now. All it does is reduce it down to cosmetic features. And by the way, just so everybody knows, California tried this and they put some of the strictest assault weapon ban legislation in place. You know what happened? The aftermarket companies started making features that bolt on, that go around the cosmetic features, and the guns became legal again. So people would change the stock in the back from a collapsible stock to a fixed stock, to the one that they like. They would get rid of the pistol grip and they would put one on with a piece in the back so your thumb can't go around it. Guess what? The exact same rifle is now legal. Did you do anything? Did you make anybody safer? No, you didn't. All this comes down to is its cosmetic features on a firearm that reduce my ability to actually own this. That's all it's going to do. Then you have a portion in there which says it has to be grandfathered if you want to keep it. Oh, it's great, grandfathering. I have to pay now for something that I already own. And who's going to be in charge of the grandfathering registry that it creates? Because it's going to create a registry, which is illegal. Constitution of Rhode Island requires, mandates that you may not have a registry in Rhode Island. So how are we going to accomplish that? I saw one version of the bill. I'm not sure if the language in here, but once you do have that registry of grandfathering, it could be shared outside of the police department. And some of the attorneys on the board would have to actually appreciate how dangerous that's going to be if that registry actually got out and people found it, people got access to it. If it's going to be registry that civilians, because there are civilians that help police departments, civilians will have access to these lists. If you remember years ago, the Providence Journal actually sued the Attorney General's office because they wanted to know who people were that had concealed carry permits. And they lost. And they said that information is not public record. This type of grandfathering might get around that. So now you're going to be able to find out everybody in Rhode Island that owns a firearm? That's a real problem. Okay. Senate Bill 469, which is the enhanced penalties of failure to report a lost or stolen firearm. It really ups the penalty on something like that. We oppose this bill. We actually, the firearms community, we make sure that people, or we tell people if something happens to your firearm, you're supposed to report it. Trying to enhance the penalty so much on something like that is just unwarranted. I don't believe that is something we should be going into. Okay. Senate Bill 636, which is the no guns in school. Every year we have to come up here and we have to speak on a different version of this bill, no guns in school. I actually was watching when the governor and people came up from the governor's team, and they actually testified on this bill. And there was personal stories that were being shared on this, and one of the stories was from a woman that does the Moms Demand Action, and how she was watching her or she was participating in a drill there at the school where her and her children were sitting in a closet trying to be quiet, pretending that there was a shooter on the premises, and they were sitting there when they were scared because of that. And she was crying because she said, how do I feel if my child was there on that? And that's why she's against this, and she wants no guns on school grounds. The problem I see with that type of story is that is absolutely evidences individuals who know nothing about security, who know nothing about how to make our children safer, who just want to go after the law-abiding citizen. Stripping away guns in school from somebody like me, I'm not the problem. Been a concealed carry holder since 1996. I'm licensed in Rhode Island, Mass, and Connecticut. That type of story, all it does is says, if I can't carry on school grounds, I have to go pick up my niece or my nephew. You know what that does? That puts me and every other law-abiding student in the law-abiding citizen in the closet with those children and the mother, hoping that nobody comes in and shoots me. I'm very well trained with my firearm. If something could happen, I could be your only line of defense for those children if something happened. All it does is put me in the closet praying that that person doesn't come in and shoot me with the rest of the kids. It does nothing for school safety. Nothing. A little more background on this, and every year we come up here and we say the same thing over and over again. In Rhode Island, if you look at all the concealed carry permit holders, the number, from either the cities and towns and from the AG, do you know it's less than 4,000 people? We have approximately 1.1 million people in Rhode Island. That's less than 0.4% of the population. We're not the problem. Making us a felon to go on school grounds doesn't make anyone safer. There's an absolute concrete fact that people will never get through their heads. Police do a great job, but they can't be everywhere. And if somebody came on the school grounds while I was dropping off my nephew, I might be the only person there that could stop that shooter. This bill would say, I can't have my firearm there. All I am is a target. I can't help those kids. I can't help the teachers. I can't help anyone. This bill is the worst thing we could do for our children. Every parent with a K through 12 child in Rhode Island should be absolutely furious at the governor and the Moms Demand Action, every town people, every year putting this bill forward, wasting the time and effort, but not making our children safer. Where's the money for the bulletproof glass? Where's the money for the extra security in our school? Where's the money for the metal detectors? We've been doing this for 6 or 7 years, and no money has been done that for those purposes. All they look at every year is us. We should get rid of those, the less than 0.4% of the population. Let's make them felons. That would make everyone safer, wouldn't it? It doesn't. And I get very passionate about this because it makes me a felon. I could be the only person that helps. And you're saying that I should be a felon because of that. It doesn't work. If you take a look at what happened in Parkland, Parkland actually studied this after the shooting. They had parents of the kids that were killed there. They didn't come there on the committee and say, let's make this a gun-free zone. What they came forward and said, we want real security for our kids. And that's what they put forward in that report. They want more security in case that happens. And if you're going to put your faith in the police departments or other places, oh yes, they're going to be the sheriffs. You can go on YouTube and you can watch a video. As the Parkland shooting was happening, there was a sheriff armed right outside the door. And he's on his radio calling it in. Yep, she's an active shooter. And what does he do? He runs away. And he gets cover and he's waiting for backup. He said he could hear in the report kids getting killed, the shots ringing out, and he didn't go in. You can't rely on the police department. The police can't be everywhere. And you may have somebody like that let those children die. If you look all across the country, after there was a school shooting, almost every one of the school departments and all the agencies have gone away from this gun-free zone. Stop bringing it up every year. You can go back 50 or 60 years and you could look at 98% of all the mass shootings happen in a gun-free zone. Why are we still talking about a gun-free zone in Rhode Island? How do we get around that? 98% of every single mass shooting is in these gun-free zones because people that are doing this are looking for soft targets. We need real security for our children. I've beat that one to death. I'm going to move to the next one. Senate Bill 84, which is the 3D printer. I don't see this as a very good or enforceable bill. We oppose it. The problem is who determines which piece would comply or does not comply with the 3D printer. 3D printer guns, there's some videos you can watch on YouTube. Good luck trying to get one to fire, because most of the time they just explode in the person's hands. It's not a realistic bill. People do use 3D printers to make grips, to make other pieces for them, and they use it to mock up parts of a firearm if they're going to be doing it. Our manufacturers actually do use CAD programs and 3D printers to actually stop making some of the new modifications to firearms to bring them to the markets. This would make manufacturing illegal in Rhode Island, so it's a real problem. I'll move on to Senate Bill 156. This would move all of the concealed carry permitting processes to the Attorney General's office. So this goes to, first problem I had with this is, I can tell you from personal experience, because I've had a permit to carry in Rhode Island since 1996, our different attorney generals that we had, some of them were actually pretty decent as far as doing the applications, processing them, getting them out quickly, and actually having a good standard of what they could be considered, they could be considered someone who's a suitable person to be licensed. But you had some AGs that when they were here, basically said, nope, I'm hardly going to give out any concealed carry permits. When Pine was in office, Pine was actually pretty decent at processing them pretty quickly. When White House was here, good luck trying to get a concealed carry permit. He was restricting them as much as possible. So if you put it just to one person, you could have an AG that decides, I'm not gonna issue them or make it very difficult. That's why we oppose the bill. First one on that one. The second one is, and it's an issue for the lawyers on here. Draw your attention to a case called Mosby versus Devine, Rhode Island Supreme Court case. There was a challenge actually to the concealed carry permitting process in Rhode Island. Mosby versus Devine actually settled that, and there was a language that people on the panel might really enjoy. It's very short. Two separate and distinct licensing procedures are set forth in the Firearms Act 1147-18 and provides for the discretionary grant of a firearm license by a department. And a mandatory licensing provision on a different one that provides, in part, any city or town, by an application of a person 21 having a bona fide residence, I'm paraphrasing, okay? So it has two different provisions. We have a shall issue and a may issue, and the Supreme Court recognized that. And the Supreme Court came down with this language, and this is very important. Because the Firearm Act provides for both discretionary and mandatory licensing of qualified applicants, the constitutional guarantee to keep and bear arms is fulfilled in Rhode Island. The Rhode Island Supreme Court said because we have two different provisions, one mandatory, one discretionary, it's constitutional. So for the lawyers up there, guess what happens when you take away one of the options on that? Come to the conclusion that what? It's unconstitutional to make it one permitting process as per the mandate of the Rhode Island Supreme Court in Mosby versus Devine. Said this before. I said this last year when a bill came up, and it came up before. Okay. Also, the bill doesn't actually have a good, also does not have a good definitional section or give you good guidelines of what a suitable person is. Okay, and the last one I'll talk about is the straw purchase, Senate Bill 638. The straw purchase, we oppose this bill. This actually could be a trap for the law-abiding citizen. Using the phrase, knew or reasonably should know if they transfer a firearm. Somebody doesn't know the person has a restraining order, doesn't have because they're not public record. That might be a problem. Somebody transfers it, they look at real quick, they go on Court Connect, there's no criminal history, they transfer the firearm. Next thing you know, they're being arrested for that. So it really is a problem. Okay, and I think I've gone over too much. People are kind of giving me the nudge that I should stop talking now. So I'd be glad to take any questions if you have any. So
I don't think there are any questions. Any questions or comments from Mr. Saccoccio? Thank you. Ma'am, good afternoon and welcome.
Hi, thank you for hearing us today. My name is Brenda Jacob. I represent Rhode Island Revolver and Rifle Association. And for the record, we're opposed to all bills but the S-597. Our members are concerned about the language of a lot of these bills. We're afraid of the words in some of these bills that are surrender, forfeiture, registration, and the words including but not limited to. There's a lot of vagueness in these bills, especially the assault rifle bill, that the definitions are a lot about cosmetic features and include firearms that we actually use in a lot of our shooting programs, even for the juniors. I want to talk a little bit about the magazine capacity bill, the S-637. That, as far as being a female shooter and a female instructor, I do have a problem with the changing of the magazines because it changes the factory specs of the firearm. And if we were to have to use magazines that were not part of the original firearm manufacturer, it becomes a safety issue. I run into this on the firing line a lot. Our women's hands are a little bit not as strong, and sometimes it affects the way the firearm recoils, so it makes it a safety issue when we're trying to teach women how to shoot safely. The No Guns in School, I'm going to just let you know that I am an instructor, and I do teach women that have been victims of domestic violence how to shoot. They do come to us, and we teach them. And I do have one woman in particular that has learned how to shoot, gone through all the proper channels, is now a CCW holder. She was a victim of domestic violence, and it was violent. And she wants to know now, if this law goes through, what happens to her when she's going to pick up her children, because now her estranged husband knows that she's unarmed when she goes to pick up her kids from school. So that is an issue that we are very concerned about. And lastly, I don't want to get into a lot of detail in the bills, but I do want to talk about our firearm community, because I really think that we get underrepresented a lot. Our firearm community is filled with grandparents, parents, moms and dads, and kids. We're business owners, we're white-collar workers, blue-collar workers. The Second Amendment in our community, we don't discriminate. And a lot of times I feel when we're up here again going through all of these bills that we feel like we're kind of getting shortchanged by our government because our safety is being put to the wayside for the safety or the feel-good safety of others. And I really don't think that that's fair, and I just know I speak for a lot of people in the firearm community. We're not just the Elmer Fuds out there. We're not out there just hunting. We're not out there just, plugging along like we get represented. We are very intelligent people, and we would want to make sure that we convey that, we do understand what's happening here, and we hope that you will consider not passing any of these bills except the Senate Bill 597. And again, I'd like to thank you for hearing our testimony and letting us voice our opinion. We do truly appreciate that. And we are also very open at any time if you have questions and want us to get into any more detail to please reach out and talk to any one of us. We appreciate your time.
Thank you very much. Are there any questions for this witness? Thank you all. Oh, Senator Lombardi.
Just one comment to correct the record. And I know you didn't mean it this way. When you say sometimes we're underrepresented, I can tell you, having been on this committee for 7 years, there's a lot of things that we may or may not do, but one of the things is we don't underrepresent. In fact, we had planned on spending tomorrow here. So we don't underrepresent, we allow everybody to speak their piece and speak their mind. So this is one place in government that is most transparent and open, I believe, is this Judiciary Committee.
Yes, we do, and we understand that, and we know you put in a lot of time, and I don't think I mean that you are underrepresenting. I probably mean more the media.
Thank you, Senator. Any other questions? Thank you very much.
Thank you.
The next witnesses we have